My name is Joseph McDaniel, and I'm an Arizona bankruptcy attorney. And since the 2005 amendments, I have a new title. I'm also a debt relief agency, and I help people file for bankruptcy under the Bankruptcy Code. And I do the same thing for businesses, exactly the way I have for the last 30 years or so. Today's discussion answers the question, what do you mean I can't file a Chapter 13 bankruptcy because I'm outside the debt limits at 11 U.S.C. 109? Well, here you go. You can't file a Chapter 13 bankruptcy. Okay, I'm wrong. You can file one, but it'll be dismissed or converted to a Chapter 7 bankruptcy by your U.S. Bankruptcy Judge for the District of Arizona. There are very nice people on the 6th floor of the Bankruptcy Court who have only one purpose in life, to determine whether you make the cut associated with the means test for a Chapter 7 bankruptcy in Arizona, or the debt limits imposed by 11 U.S.C. Section 109 for a Chapter 13 bankruptcy in Arizona. It's been interesting to watch the debt limits for Chapter 13s creep up over the years. The last time I checked, and don't hold me to this entire discussion is just a discussion, and it doesn't create an attorney-client relationship, and it doesn't constitute legal advice. Find your own Arizona bankruptcy attorney who's board certified, AVVO 10 rated, AV peer review rated by Martindale, or just a former chairman of everything with a lot of experience, or just a lawyer from around the corner. Your choice. The limits for debt under Chapter 13 are $1,010,650 secured and $336,900 unsecured. And that can change at any old time. Either number can knock you out of the box for a Chapter 13 bankruptcy case. Are there exceptions? Well, does a bear say mass in the woods when nobody is around to hear? Of course. And I'll talk about those exceptions in a later discussion. Note, if your debt is too large for a Chapter 13, you may be one of the lucky ones, because slogging through a Chapter 13 bankruptcy in Arizona is an expensive, time-consuming, detail-oriented project that makes a Chapter 7 bankruptcy look like a walk in the park. I used to spend one day a month overnight at the Bankruptcy Court when I was a law clerk for the chief bankruptcy judge there, with my pocket calculator in my hand, writing memos on which Chapter 13 cases should be confirmed by Chief Judge Caldwell. And that was back in the good old days, when Chapter 13 cases in Arizona were fun and easy, and the debtor got the neato super discharge, which sounds a little like what happens before you have a lower GI and they give you the soda pop from heck to drink, but it's not. And you no longer have to worry about whether you'll get your super discharge in a Chapter 13 case, because that's long gone with the 2005 amendments to the Bankruptcy Code. And not just here in Phoenix, Arizona, but everywhere in the United States. Because bankruptcy law is federal law, although the law of property is state law, and most states are opt-out states, which makes applying the state law of property and the Arizona state exemptions to the federal bankruptcy code slightly interesting. It gets crazier by far when you try to track down the relationship between the federal law of bankruptcy and the domestic relations law, which is typically exclusively state law. And the handful of community property states, and Arizona is a community property state, are all somewhat different from one another. So it's party time when it's time to analyze those relationships. Thank you very much.